Good morning, everyone. My name's Steve Champion, and with me is Tim McDonald. Just some introductions. ER Strategies. We're approaching 23 years in business in a couple of weeks. We've got clients in franchising, financial services, manufacturing. We're also the employment compliance partner for the Franchise Council of Australia. My background, I've got close to 40 years experience in the industrial relation field. I've worked in senior roles in manufacturing, power, timber, club industry, fast food, all of those things before establishing ER Strategies in 1999. Tim, a bit about yourself.
Thanks, Steve. So I've been working in the area as a lawyer for over 20 years. I've worked in law firm situations. I was also at an employer organisation running their industrial relations for a fair while. I was also a senior advisor to the Commonwealth Minister for Employment and Industrial Relations. And so in that role, I had responsibility for legislation that might impact independent contractors. And as a lawyer, I've been involved in a number of cases that have wound their way through the courts up to the High Court, dealing with these sorts of issues. McCabes is a full-service national law firm. While we might be described as medium-sized, we like to think that we've got very much a boutique client-focused culture.
Just a reminder, this, you've probably seen it anyway, but this presentation is being recorded, and we'll be able to share a link to the recording with you sometime after the event. So just moving on now to the agenda for today. Let's make sure we're presenting everything correctly. So the agenda, first of all, we'll kick off with a bit of the background of why the whole issue of employee versus contractor is so important. Just struggling here to advance things. Oh, okay. Also, some of the difficulties that comes around from uncertainty related to the whole distinction between employees and contractors. There's been a recent change in approach by the High Court, and having Tim here today to talk about that, about those changes, will be invaluable, I think, for a lot of people on this call. Also, just briefly consider with the new Labor government coming in, whether that might have some impact as well. And also, obviously, you want to have some key takeaways from today so that you can apply or make sure you're doing things correctly, so you don't get yourself in the strife. And there'll be plenty of opportunity for questions and answers. You can use the chat function to raise things during the presentation. We'll also have the opportunity for questions and answers at the end as well. So, Tim, why does it matter so much about this distinction between contractors and employees? Can you take us through that?
Sure. I think the distinction matters in a number of ways. So at one level, it matters about employee entitlements. So if you're an employee, you're entitled to minimum wages, you're entitled to annual leave, long service leave, redundancy, and all of the national employment standards under the Fair Work Act. There might be award coverage or enterprise agreement coverage as well. Whereas as a contractor, I think the expectation is that you're more in business on your own account, so you wouldn't have those types of entitlements. But where it sort of matters is that if it's quite often arrangements are mutually acceptable for an independent contractor relationship, and then one day for some reason or another things break down. Maybe you want to terminate the independent contractor arrangement, or perhaps they go off to a competitor and then they want to question their arrangement. So what might happen is that those mutually acceptable arrangements then come into question, and then when that happens, it can be very tricky because the people say, well, I might have been for the last 20 years working as an independent contractor, but I was really like an employee, and I didn't get annual leave, I didn't get long service leave and so forth, and they can claim those things. And while there's a limit for some things under the Fair Work Act, going back 6 years, for things like annual leave and long service leave, they can generally go back a lot further than that. Then there's also different rights under legislation. So if an employee is terminated, for example, they can bring an unfair dismissal case. But other than perhaps owner-drivers in New South Wales, generally there's no right for contractors to bring an unfair dismissal claim. This is different in other parts of the world. So in the UK, for example, independent contractors are able to bring unfair dismissal claims. Then there's contractual rights and obligations. So as an employee, there's a duty to be loyal to your employer. And a lot of things just sort of flow from that. You expect people, for example, to keep any information confidential that they come across during the course of their employment. You're not expecting that they're going to be sort of feeding information to competitors or anything like that. But as an independent contractor, there aren't those obligations. There's no particular obligation of loyalty. The idea is they're in business on their own account. So if they want to work for other people, perhaps competitors, generally they're entitled to, unless there are particular things that you try to address in the contract with them. And then sometimes issues arise where someone gets hurt, whether that be an employee or independent contractor, or perhaps a third party. So one of the cases that went to the High Court, famous one, it was about crisis couriers, and a bicycle courier ran into someone in the street, and they got a bung knee as a result. And then they went to sue crisis couriers, and crisis couriers said, well, it was an independent contractor bicycle courier. And then they said, well, what's his name? And he was a backpacker. He'd gone back overseas, and the person who was injured, wanted to get some redress. And I suppose that's that becomes very difficult. Or sometimes someone who might be an independent contractor gets injured at work, and then they seek workers' compensation. So sometimes that's another way that these things arise, even though no one was necessarily expecting it. Then there are various other sort of statutory type entitlements, superannuation under the superannuation guarantee legislation. That can be very tricky in relation to contractors. Generally, if someone's a company, is incorporated, then likelihood is that superannuation is going to apply. But in circumstances, even if they are a contractor but spend 80% of their time working at a particular business, then in those circumstances they can be liable. And then there can also be issues about payroll tax and workers' compensation and who's liable for insurance. So all these things I think really need to be thought about in terms of how you structure the arrangement, looking at your legislative obligations and also what's in the contractual terms.
So with so much hanging on that distinction between being an employee or a contractor, what sort of tests have the courts applied to distinguish the two sorts of relationships in the past?
Yeah, this is an area where the tests are fairly sort of rubbery. They've developed what's called a multi-factor test, where they look at various indicators which might point to someone being an employee or an independent contractor, which really sort of involves a judge trying to sort of get an impression of the overall relationship. So there are a number of factors that they look at. One is sort of what the parties intended. So did parties intend for it to be an independent contractor relationship? And if they did, traditionally there's been some importance placed on that, but it depends. But it can depend. So that if, for example, a relationship's been called an independent contractor relationship, but on closer analysis it isn't, you can't make something that looks like a duck and quacks like a duck not a duck. That's a famous line from the judges like to roll out. But sometimes where it could go either way, as to whether it's an employer or independent contractor relationship, it can be influential about how you've described the relationship. One of the big things is whether you've got an ability to delegate work. So if you can, traditionally the idea of an independent contractor is that the person's in their own business. If they want to, they can incorporate, they might start to employ other people, and they might try to expand the business. That's the whole idea. So if someone can employ other people, that's always a very strong indicator that it's an independent contractor type of relationship. Then there's just one thing I might just mention there in terms of that subcontracting. One of the things that has become a particular problem is that under some regulations, for example, in the financial services area, it's very difficult to have subcontracting type arrangements. There can be obligations that if you're a licensee, then you've got to deliver personal service, and that really creates a bit of a problem when you're applying these tests of whether someone's an independent contractor or not. It is really important as to whether they can delegate their work to other people. In terms of the other thing is the amount of control that can be exercised over the person, and this is always a tricky area as well. You know, 100 years ago, there was these command and control structures were very clear as to, you know, people being servants and masters and all that sort of thing. But that's not the way the world works these days. So even if you're in an independent contracting relationship, there's going to be a certain level of control that's exercised, even, for example, with work health and safety. And there's a lot of regulation that goes into that. And the expectations of whether someone's an employer or independent contractor, they're sort of fitting in with what your requirements are. And then there's financial responsibility and risk. If someone's going to have be an independent contractor and have a business, then I suppose the idea is that they might take some risk. I suppose the traditional example might be a truck driver. If they go and buy a big truck and they want to get some return on that investment, they're probably loan money to get the truck. That's a key consideration in terms of whether someone's their own business. Is there a level of entrepreneurship involved? Are they taking a risk? Is there perhaps a capital investment involved? I suppose that overlaps really with the next one about whether they supply their own tools and equipment. Where someone does supply equipment, often expensive capital equipment, it's going to be more likely that they're going to be a contractor. If you think about drivers, for example, if someone's got a semi-trailer, well, they're probably more likely to be an independent contractor. If, for example, they use the family vehicle sometimes to deliver things, it might be a little bit more borderline. Once you start talking about bicycles, it becomes a little bit more iffy about, well, really, have they expended much? If they're just using their bicycle, is that really a strong indicator of them running their own business? The next one is hours of work. And sometimes you see relationships with independent contractors, they just develop over time, and people sort of get into this situation almost treating them like employees where they come in and just work the same hours as everyone else. Maybe there's an expectation that they do that. Now, in those circumstances, you're going to run into risks. If they're working employee-like hours, well, that can be problematic. Whereas an independent contractor would generally be someone who is going to be paid for doing a particular job, and they can work as many or few hours in order to be able to do it and resource the work as they see fit. Then there's also a question about whether work is continuing. So an independent contractor generally won't have sort of any long-term expectation of work other than for the particular job or task that they're doing. But if there is an expectation that there's going to be ongoing work from week to week, that's generally an indicator of an employment relationship. There are also other things such as tax, which can become important. If someone's got an ABN, quite often that's an indicator that they're not an employee as compared to someone who gets PAYG earnings. Sometimes if it's sort of set up as a corporate structure, that can also be an indicator. Although this is an area that's got really sort of tricky. There was one of the cases that been recently decided by the federal court was a case of Tripanovsky and Ace Insurance. Now, in that case, the claimant who had been independent contractor many years, so it was thought, in that case, there was a company structure employed a couple of people, and it was said, well, you know, in terms of the tax sort of suggests that maybe it's an independent contractor relationship, but maybe the company really was just a way of the person getting tax advantages in terms of the relationship. So then the court disregarded it. So it can be a pretty tricky area. But if someone's set up as an ABN or a company, then it's probably going to point more to an independent contractor type situation. And then with superannuation, someone's a company, that generally means that superannuation isn't payable to them. But if they're not a company, then they spend 80% of their time working for a particular business, then that business can be liable for superannuation. I suppose the other thing is whether people get leave, that would generally be an indicator that they're more of an employee-like person rather than an independent contractor.
Yeah, on Tim, on superannuation, I think there's even something in the legislation, in the SGC legislation, that if the contract is primarily for labour, well then, even then, there's an entitlement for super.
That's you're spot on, Steve. There's so if the contractor, so generally the view is if you have a company and your contractor's that, even if the contract is principally for labour, that superannuation is payable. But if the contract's principally for labour, then in those circumstances superannuation would be payable. So say using that truck driver example I gave before, chances are that if someone's got a semi-trailer, well, there's going to be the majority of the money that they earn is for the use of the capital equipment. Come to the use of the family vehicle, it becomes less so. Come to the use of a bicycle, chances are that the majority of what people are being paid is for their labour rather than their equipment and so forth. So in that case, that they would be liable for superannuation. But it can be a bit of a quirk that can come back to bite people. One of the things that Labor is proposing is that people would have a right to be able to pursue super, whereas at the moment it's always had to have been done through the ATO, through the superannuation guarantee charge. So I think this is a bit of a sleeper area, Steve.
Yeah, well, we're looking at all these various traditional tests, and I've got to say that I thought I was pretty much on top of all of this stuff. It was only recently that I realised, oh, hold on, something's changed in terms of the approach from the High Court, which we'll get to shortly. But you can see that all of these different considerations are going to create some sort of uncertainty, because if you it's not just one single thing you've got to look at. You've got to look at a whole range of factors, and the court's looking at that. That's where there's going to be a problem. In fact, there's a question that's come in. We might just deal with it here. The question is, our 100% labour subcontractors don't want to convert to casual, presumably from a contractor relationship. So what do? Our industry is desperate for workers. So you've got a situation where the people who are in that position, calling themselves a contractor, want to be a contractor. What are some of the issues there, Tim?
No, I think that's a fairly common sort of situation. People like quite often the tax advantages, extra pay of being a contractor, and I suppose then you've got to sort of weigh up, well, what's the risk? Is there a risk that they might be found to be independent contractors or not? Generally, and I'll talk about this a bit more as we go through, but if you have a clear contract in place, making it very obvious that it's an independent contractor relationship, that's going to be a good start. And there are ways that you can, through that contract, try to protect yourself. So if, for example, they were to challenge that they were the nature of the relationship, there might be that they might have to indemnify you in relation to that. There might be various offsetting things. There are a number of things that you can do in the contract to try and get protection. But I suppose you've got to make a call first off. Look, are these people really contractors or not? And sometimes, while they all might be consensual for a while, sometimes if things sour in the relationship or you want to terminate the relationship, the landscape quickly changes on that score.
Okay. And talking about change, so what has changed in terms of these high court decisions recently?
Yeah, so I think with the multifactorial test that I was talking about, the courts have, that's been the case for many years that these factors would be considered, and the judge would form an impression about what the nature of the relationship was. But what was happening was that it wasn't just it was quite often looking at situations some years down the track and looking at how the relationship had developed. And what seemed to be happening was that the judges were saying that they would look to the reality of the relationship. And that sort of sounds sensible at one level, but the problem was that they would then not necessarily look at what the parties had contracted for themselves. What they'd look at is how things had developed. And sometimes over time, you've been with a contractor's been with you for a long time. They tend to get into a groove, work fairly regular hours, and sometimes appear to be part of the furniture. And then the courts would look at that situation and say, well, this person, they seem to be working 38 hours a week. They don't seem to have any other clients, even though they might be able to. They don't seem to. They're getting all their money from you. So really, don't they look like a contractor? So what was happening was that by looking at this reality of the situation and how things had started to operate in practice, it seemed as though all these arrangements that had been entered into on the basis that they were clearly independent contractor relationships were being struck down. And what the High Court did in a couple of recent cases is say, well, hang on, let's rethink this. People are contracting in a certain way. We should be respecting the contract, and rather than looking at what's happening in practice, we've got to actually focus on what the legal rights and obligations of the parties are. And the best way to do that is to look at what's actually in the contract. They said, while the multifactorial test might be a useful sort of guide in circumstances where there's no contract in place and a court's trying to work out what the nature of the relationship is, where people have actually committed something to writing, what you should look at is what the terms are, what are the rights and obligations. So they've sort of moved very much away from even looking at what people have sort of decided the relationship should look like. It's really looking at the terms of the contract and saying, well, do they have a right, for example, to employ other people? Could they incorporate if they want to? What are the tax arrangements? A whole range of things are going to be looked at now, but it's the written contract now that's king. And we've seen this sort of change in the High Court, and this is happening. People are probably aware this happened in relation to casuals as well. In the Rosado case, they said, look, we've got to really sort of go back to look at what's in the contract, and they repeated this in relation to contractors. And I'll talk about those decisions shortly.
Okay, so it's probably timely then to start look at these actual decisions of the High Court to see what the situation was and what the outcome was.
Yeah, thanks, Steve. So there were two decisions that were handed down at the same time, and one of them was dealing with truck drivers, and the other dealer was dealing with labour in construction. The first of the cases is this ZG operations case, Jamesk. This was a case about a couple of drivers who had been driving for Thorn Lighting. Thorn Lighting said, look, we don't want to employ drivers anymore. If you like, you can do our cartage for us, but you'd do that as independent contractors. You'd have to supply the vehicles. You'd be free to go and do work for others, but we'll just have this arrangement in terms of cartage for us. There were contracts entered into. The two drivers went into partnership with their wives and contracted that way. And the contracts made it very clear that they can work for others. They're in control of things, and they can arrange how they do the cartage. But what happened over time was that it was a fairly comfortable situation. They were getting enough work just from doing the cartage for Thorn Lighting, and that sort of suited them. So they didn't really look at trying to get other work. And then when Thorn Lighting decided that they no longer wanted to continue the arrangement, they claimed that they were in fact employees, because and in doing that they sort of pointed to the fact that they worked generally 38 hours for Thorn Lighting and had done so for many years, and said, well, look, in practice we're really just like employees of Thorn Lighting. So the full federal court had agreed with them, and then went to the High Court, and they said, well, hang on a sec, there are contracts in place here. They've sort of set up partnership arrangements. They've given some attention. They've made some pretty deliberate decisions about how they wanted to structure their business. And while they didn't necessarily do work for other clients, they very much clearly had the right to. It was really their choice in terms of how they ran the business. But they could have gone sought other clients. They could have put on more people. They could have bought other trucks if they wanted to. The fact that they hadn't didn't mean that they became employees. And they said, we've really got to go back to what the terms of the contract are to work that out.
Yeah, interesting, Tim, that you've got the federal court saying they're contractors, then the full federal court on appeal saying they're employees, then the High Court saying, well, yeah, we don't disagree. We don't agree with the full federal court, so we reckon they're contractors again. I mean, if the courts can't agree, imagine how hard it is for a business to get it right. It's just a complex situation.
You're right, Stephen. It is a nightmare for businesses, because you think that you're entering into a contract in good faith. Everyone's sort of on board. Everyone goes into it with eyes wide open, and you think, well, we're all observing this contract, and then 20 years down the track, people sort of say, oh no, look, I don't. I'd like it to be a different thing. And by the way, you haven't paid me any annual leave for the last 20 years. And it really becomes a problem. So I think you're right. There's sort of lack of certainty about the arrangement, and it's very much a matter of what impression a particular judge forms at the time, weighing up all these indicators. That wasn't really conducive to any sort of certainty or any sort of regularisation, if you like, of judgment. So, as a lawyer, it was pretty hard to predict quite often how a particular case would go, and sometimes it depended on the form of a particular judge and that sort of thing. But that's no basis to sort of operate a business on with any sort of certainty. So I think what the High Court's done is introduce a much greater level of certainty if people really turn their minds to written contracts and so forth, which I think is a very positive development.
Yeah, and look, over the years, what we've had to do in advising our clients on these sort of issues is to say, look, make it as black and white as possible. 50 Shades of Grey is not going to help you. So therefore, you'd be saying to the client, well, don't have it airy-fairy stuck in the middle somewhere. Make sure it's absolutely clear that it's a contractor relationship. But in real life, that can be quite a difficult situation. Things can change over the years. You can end up in a grey situation, and that's not helpful. Okay, so the next case.
Yeah, this was sort of went the other way. So this was a case brought by the construction union against Personnel Contracting, which was a labour hire company that was specialising in the construction industry, and they had a setup which was often termed an odd-co arrangement, whereby they would the individuals that they would put out to jobs were independent contractors rather than employees of the labour hire company. And in this case, what had happened was they'd engaged a backpacker. He didn't have any particular skills, and he would do sort of a bit of cleaning up, basic labouring sort of work. And they would sign him up to an administrative services agreement. And under that agreement, the labour hire company would set the rate that he would be paid. He didn't have any say in it. They could determine where he was going to be sent for work. And then when he went there for work, the client would direct him as to the work that was going to be performed. So funnily enough, the full federal court in that one said, yeah, look, that's an independent contractor relationship. And then it went to the High Court and they disagreed. So in the High Court, they said, well, he really wasn't in his own business. He was in the labour hire company's business. And what the labour hire company was selling as a business was having a compliant workforce that they could send out to clients' premises to do work. And because he didn't have any sort of say over what he was paid, where he worked, how he worked, that in that sort of circumstance, that it was all the hallmarks of an employment relationship. So what the court, so in coming to its decision, what the court did was they looked at, well, what were the terms of the contract, and in particular the term about him not being able to have any say in his own pay, not being able to have any say in where he worked, were key factors that the court said that even though the parties tried to label the arrangement as an independent contractor one, it was in fact really an employment one because of the rights and obligations they had set for themselves under the contract. And I think the message in this is that where you have independent contractors, you've got to be careful not to overreach on the contract. So if you're going to if you want to make sure it's an independent contractor arrangement, you're going to have to think about, well, to what extent do I regulate that person? For example, if you start saying they can only work for you and they've got to work 38 hours per week, then you're going to run into problems in terms of people looking at it and saying that doesn't seem to be consistent with a contractor type relationship.
Yeah, there's some comments that have come in, one of which is the person's heard of various percentages thrown about around how much time a contractor can work within the business. There's 20%, 80% working for the one business. And we're not, I'm certainly not a tax advisor, but I think what that could be referencing is actually PAYG. But I think if 80% or more of the work is with the one employer, well then that employer has to take out PAYG income tax, unless you're in a personal services business. So you're getting into complex areas of tax. It all gets wrapped up into this, well, are they contractors, are they employees? Because you can get a different result from tax, say superannuation, than you might get from the common law situation for, say, annual leave or sick leave or something, or award entitlements.
Yeah, it certainly muddies it can muddy the waters, so because you've got different tests. So as Steve mentioned, you've got the common law test about whether someone's an employee or contractor for, say, annual leave and employee entitlements. But then when you start talking about workers' comp, there's often an extended definition of contractor. For payroll tax, there's an extended definition of contractor. So it's not enough that they be a contractor. There are various other things that you've got to look at. So that muddies the waters. And then with superannuation, you look at whether the majority of the workers for labour, except in circumstances where they might be incorporated. But this is, even on that superannuation point, there's still, even though there are so many contractors around, you'd think there was a clear answer to this. There's still a lot of legal doubt about, well, what happens where someone is a company? Do you not have to pay them superannuation, even in circumstances where they're getting the majority of their revenue from one particular business? So some of these things are still yet to be grappled with by the courts.
Okay, well, at least it seems like there's a positive step forward here in that the the High Court is saying pay a lot more regard to the written contract.
That's right. Yep.
Okay, so it's adding clarity rather than making it worse. So that's a good thing. We've got a new Labor government in power, the new Albanese Labor government. Can you just perhaps make some comments there about the situation likely to change as a result of the new government?
Yeah, I mean, the ALP's been very clear in their platform that they want to regulate the gig economy and make sure that the Fair Work Commission has powers to set terms and conditions of employment for workers in the gig economy. One thing which is really sort of unclear, though, is, well, what is the gig economy and what are workers? And what is going to be the reach of this stuff? So, I mean, we've seen the driver, the people who are delivering fast food and all that sort of thing, questions about them and Uber and so forth. And I think maybe that's the type of thing that the government has in mind, but it's very hard to sort of isolate these things. In Victoria, they've had an inquiry about it, and they were talking about maybe regulating what they regarded as entrepreneurial workers. So independent contractors that didn't have other employees, but did have entrepreneurial type arrangements. I'm not sure whether that's something that the federal government's going to go for, but they've certainly said employee-like forms of employment will be covered. And one of the things that sort of worries me about this is there had been a road safety remuneration tribunal which the contractor drivers could set rates and conditions, and that had been abolished by the previous government. But now it seems as though that's going to be picked up within this. So the other thing is that when they've talked about what the gig economy is, they're not just, it doesn't seem as though it's just some of these platforms that we traditionally think about. They've talked about, for example, NDIS workers, carers and so forth, who are independent contractors, also being regulated under this sort of arrangement. So I'm concerned that this could be reasonably far-reaching in terms of the powers that they might give to the Fair Work Commission. And of course, how they exercise those powers might be a different matter as to whether it's going to be a fairly soft touch level of regulation or something a lot more. But I think we can expect that there's going to be some further regulation in this area.
Yeah, I've read recently of some of these businesses. I'm not sure which one it was, Menulog or one of those sorts of businesses, actually making steps to talk to the unions about establishing more employment-like conditions. So taking a lead in it rather than just letting it happen to them. It'll be interesting to see how this whole space plays out.
I think it is hard because to a lot of sort of gig economy type businesses, that they're also trying to look after their contractors as well. So it might be that they try to make arrangements that they can to facilitate them getting home loans, or it might be that they make arrangements for various insurances that they can get and some employee-like benefits. But in a way, it becomes a bit counterintuitive, because once they start doing those things, then people say, well, aren't those things more employee-like? So we're getting into this situation where it's sort of, yes, they're independent contractors, but to some extent, the principal is starting to sort of look at ways that they might be able to make it more attractive for those independent contractors. And we're running into a lot of issues about how that's going to sort of work in practice, even though it's all very much well intended from the principal contractor's point of view.
Okay, so look, I guess what everybody wants to know is, look, just don't tell me everything's uncertain. Tell me what I've got to do. So what are some of the key takeaways from these recent High Court decisions?
I think number one thing is just be realistic about the relationship. So try and have it, if it is going to be an independent contractor relationship, recognise that there are going to be certain freedoms or flexibilities that there aren't going to be an employment relationship. So, but then once you've decided what you want, you should be very clear about it in terms of the contract that you have. And if you put something in writing, that's going to be the absolute best protection, because everyone's clear on what the arrangements are and what the rights and obligations are under that contract. And the thing that you should also do is make it clear that the written contract is the thing that regulates everything. So even if other practices start to develop at all, everything is, any legal rights and obligations are set out in that contract. And then if they're clear, then that's going to give you a big step forward in terms of securing the arrangement if it was ever subject to testing. So it's one of those areas where there's a lot of importance in turning your mind to those contracts and making sure that you get them right.
And there's some concern about labour hire arrangements.
Yeah, I think that one of the things that came out of that case with personnel contracting was that this ODCO type arrangement, where there might be individuals that are being supplied through labour hire companies that aren't really independent businesses, that can be a big problem. So I had one of those with a real estate business where the number of people questioned whether they were contractors or employees. Once they did that, it became a problem because the business wasn't able to fund employee entitlements. So then the people who had been independent contractors were then coming after the client principals and seeking payment for them. So I think just to exercise some care if independent contractors are being supplied, make sure that there are appropriate arrangements in place so that you're not saddled with any underpayment type issues.
We'll get into considering some real life situations shortly, but just to summarise again that this slide, Tim, I guess it's a critical thing. What do people do differently? Okay, the High Court's saying they have greater regard to the written contract, so obviously make sure you put your contractor arrangements into writing, but you also want to review the written contracts just to make sure that it's consistent. Is that what you're saying?
Yeah, that's right. So they should line up. But if you think about the rights and obligations, you set them out in the contract, and they're consistent with the type of relationship, you're a long way forward.
Okay. So just want to give the opportunity for people to ask questions. but maybe considering some real life situations. We were talking before, and I know there's a lot of people on this webinar with a financial services background. You touched on some of the license complexities before. How might it work? Look, we get calls from our clients about, say, we've got mortgage brokers, and this is a separate one to the license issue. Can they be independent contractors, or how do we do this? So obviously we're going to have a written agreement, but you've got the mortgage broker working in the office of, say, a lending brokerage. How can that work?
These things can be tricky because, and quite often there are well-settled arrangements in place, and so you don't want to create any legal uncertainty about them. But very much sort of this idea of looking at what the rights and obligations under the contract are important. But one of the things that I think has been difficult in the financial services area is that there's so much regulation of licensees. And so many restrictions on the ability to subcontract the work that you get into situations where you can't, for example, just start a business perhaps as doing, say, mortgage broking or something like that, and then employ a whole lot of staff also doing mortgage broking. So that creates problems from a control perspective, and then there can also be, sometimes there's a particular concern about maybe working for other mortgage brokers and things like that. So I think you've got to first off start with the written contract, but you've got to give a considerable thought to making sure that the rights and obligations under that contract are going to line up, and it becomes hard because of some of those regulations that are around. There was a case, Ace and Trivanovsky, which was about someone who was an insurance sales person, door to door, was highly paid, had a company, engaged a couple of admin staff to help, ran his own car and that sort of thing, paid really quite big money on a commission basis. And the federal court in that case, the full federal court, decided that even though he'd been an independent contractor on paper, that there seemed to be a commitment that he'd work 38 hours per week. That's what he'd always done. And in effect, he couldn't really do anything other than render personal services because of the way the financial services regulation works. So that was certainly a very difficult one for when it was decided that he was an employee, because there was just so much back pay involved with that company. But I think it typifies the sort of issues that arise in financial services. So I'm certainly not saying you can't do it, but there is a risk, and you've got to give a lot of thought about how you structure the contract. And even sometimes with the contracts, making sure that there are protections. So, for example, if someone was to bring a claim, are there some protections under that they have to indemnify the employer? How do those things work, and are they legally enforceable? There's a lot of things to work through. So where there are areas of doubt, maybe that's sort of a point where you've really got to give a lot more attention to the contract, and sometimes other things like making sure, for example, that the people you're contracting with are incorporated and things like that. If you sort of set it up so that it looks like an arm's length business, it's always going to be able to be one that's going to more easily stand the test of time.
Yeah, so you've touched a couple of times on Trivanovsky. That might make people think, oh, hold on, I'm confused now. That was the previous sort of approach of the High Court, or is it still going to be a problem in those sorts of areas?
Yeah, look, I don't think this is. I think there's still a lot of things to be sorted out, but certainly the step that the High Court has taken things a whole lot further. And say that Trivanovsky case, for example, might be decided differently now in light of the High Court decision. But I suppose I just caution too that there's making sure that you get everything right on paper, but you've also got to think about the type of business that you're in and what the expectations are in that relationship, and whether that easily fits within the independent contractor or an employment type model.
Look, there's a question that's come in. Can we convert a subcontractor to casual and just take the super amount off the usual hourly charge? So I guess what you've been doing is treating them as a contractor, and then you're just going to unilaterally perhaps change them to be a casual employee. Where does that leave the employer or the principal of the business?
I mean, I suppose an independent contractor doesn't have the security of employment that an employee would have. So there's much greater ability to be able to terminate the contract. There are some limited rights they might have under the Independent Contractors Act to be able to seek reasonable notice if there's not something specified in the contract. But let's say you do have a contract and it says that you can terminate the contract on a week's notice, then you're free to do it. And you know, under the what the High Court has said, that would certainly give you some comfort in doing that. So you could make that change. It's harder to go from to convert someone from an employee to a contractor, but converting someone from a contractor to an employee is easier. But I suppose that's sort of the legal answer, but there's also a practical answer about, well, if you want to get the people to continue on, how's that all going to work? But conceivably, you can terminate the independent contractor arrangement, make an employee arrangement, but they will have to, you'll need to get some agreement. If you can't get agreement, then I suppose that relationship just comes to an end.
Right. Okay. I guess if you can do it by agreement with the person and say, look, I'll give you more certainty in your entitlements and the ongoing work, or maybe the person will be on board with that. If you just do it to them, they might go, well, stuff you. That's right. I'll see you in court.
Exactly.
Okay. Another question's come in. What about massage therapists? We provide the room based on their availability. Both parties help make the bookings, recommend treatment, etc. We provide basic equipment, but they supply any of their specialised consumables or hot stones, dry needles, etc. Okay, so I guess the question is, can that be a contractor, independent contractor relationship?
Yeah, it's a hard one. I think that one's it can be pretty line ball. So. And it might depend on the particular circumstances. So let's say, for example, that the massage therapist had a company and supplied services. Then in that type of circumstance, that might be okay. It might be clearly an independent contractor relationship. Let's say if that massage therapist was unwell, that they could send someone else to fill in for them, or perhaps they could employ other people and perhaps provide services at a number of places. They're very much sort of independent contractor type relationships. It might start to become more borderline if it's a situation where the massage therapist only works for one particular place, and then you might sort of question, well, are they really in business of their own, or are they in business for someone else? And going back to that personal contracting, that personnel case that I talked about with the backpacker and so forth, yeah, how much freedom do they have about sort of setting their own rates and all that sort of thing? So yes, it can be an independent contractor relationship, but it would be hard if that person's not incorporated and just providing personal service for the one principal.
Mm. So just to try to bring all this together, I guess there were those multifactorial tests before. I think they're still important and relevant, but there's just a greater emphasis on the written contract. Is that what the change is here, Tim, just to summarise it?
Yeah, look, I think that's it in a nutshell, Steve.
Okay. Look, I think we've sort of covered the area as best we can in a webinar such as this. There's our contact details if you want to discuss this in more depth. And I think that's what you've got to do. Like, you can't necessarily just assume every situation now. It's a written contract, that's fine. We're in the clear. But it's become clearer than it used to be. But you still have to have regard to those other tests, those multifactorial tests. So there still is a need to get advice on this sort of stuff. It is a complex area, and you don't want to get it wrong, because if you end up with a big liability that's unfunded, you weren't aware of, that would be a fairly major surprise to you and not one you want to have. So still get advice. Yeah, Tim has mentioned that he's been involved in some fairly major cases over the years in this area, so he's very skilled in this area. Day-to-day sort of stuff, ER strategies, we're more than happy to help out in giving advice. So it's a matter of still having regard to those multi-factor tests, making sure you're not trying to call the duck not a duck when it obviously is a duck, but having you can have some greater assurance, I guess, now if you have the written contracts in place and everyone's working consistently with that, and the whole relationship, isn't can fit within what you've called it. If it, you're not trying to call a goose a duck, well then, you can get by. So still get advice, but hopefully there's some more clarity in this area because it has been a very difficult area over the years, and you've just have to still make it as black and white as you can, but supporting that with the written agreement. Anything you want to add to that, Tim?
No, thanks, Steve.
Okay, look, thanks very much, everybody, for joining us today. Hope you've found this instructive. And as we've said, we've recorded this and we'll be able to provide a link to it afterwards. Really appreciate you joining us today, and have a good day, and keep well. Thanks very much for your attendance today. Bye.
Thanks, everyone.